Hey, welcome. So today we're diving into a really fascinating legal puzzle. How can a court actually rule on a case that's, well, already over? It sounds impossible, right? But there's this incredible tool that lets judges essentially hit a replay button on lawsuits that have expired. It's all about making sure justice doesn't get denied just because the clock ran out. Let's get into it. Okay, so imagine this. You sue to challenge a new, restrictive voting law. But the court system, it moves slowly. And by the time your case gets anywhere, the election's already over. Or maybe you're fighting a short-term government order that expires before a judge ever hears your argument. The problem itself has vanished. So, does the lawsuit just disappear too? For the courts, this is a massive problem. And this brings us to a foundational legal concept called mootness. Now, under the U.S. Constitution, federal courts are only supposed to rule on actual, live controversies. They're not there to give out advice or answer what-if questions. So, if the central conflict in a case just resolves itself, that case is considered moot, and boom, it usually gets dismissed.
But you can probably see where this is going, right? This whole mootness thing creates what we can call the vanishing lawsuit problem. I mean, what are we supposed to do about super important legal issues that, just by their nature, are over and done with before the courts can even catch up?
Think about it. If every single challenge to a temporary voting rule becomes moot the day after the election, how could any of those laws ever be challenged in a higher court? It creates this black hole where really critical issues that affect tons of people could never, ever get a final ruling. Justice could get totally stuck.
So, to fix this, the Supreme Court came up with a pretty clever solution, something that acts like a legal replay button. It's a hugely important exception to that mootness rule we just talked about.
And they gave it this very descriptive name, capable of repetition, yet evading review. The name really says it all, doesn't it? It's designed for problems that are almost certainly going to happen again, but are just too short-lived for the legal system to grab onto in time. This makes sure that these vital, time-sensitive issues don't just become immune to any kind of judicial review.
So how does a court actually decide when to use this legal replay button? Well, they use a really specific two-part test. First, the thing being challenged has to be inherently short-term. It's over too fast for the normal court process. And second, and you really want to remember this part, there has to be a reasonable chance that the very same person who filed the lawsuit is going to face the exact same problem all over again. You gotta have both.
Now, I know that might sound a little bit abstract, so let's look at how this all works in the real world with some major cases. This is where you can really see just how powerful this doctrine can be.
The textbook example, the one everyone learns, involves challenges to abortion laws. I mean, think about it. A pregnancy lasts about 9 months, but a major constitutional case, that can take years to wind its way up through the appeals process. By the time that case ever gets to the Supreme Court, the woman who filed it is no longer pregnant, which you'd think would make her case moot.
But in the landmark 1973 case Roe v. Wade, the Supreme Court tackled this exact issue. They used this doctrine, and they said, and I'm quoting here, pregnancy provides a classic justification for a conclusion of non-mootness. They pointed out that without this exception, these kinds of challenges could never reach them. And crucially, they reasoned that pregnancy could happen again to the same woman, which satisfied that all-important second prong of the test.
Now you see the same logic pop up all the time in another super fast-paced area, election law. The time between filing to run for office and election day is, in legal terms, the blink of an eye. Lawsuits challenging who gets on a ballot or what the campaign finance rules are just can't get resolved before the votes are all counted.
And the courts have been pretty consistent here. You look at a case like FEC versus Wisconsin Right to Life, and the court heard a challenge to add restrictions long after the 2004 election was over because the group suing was very likely to run similar ads in the future. In other cases like Moore v. Ogilvy or Storer v. Brown, the court basically said, look, even if this specific election is over, the underlying rules are still there and they will persist, affecting candidates in every future election.
Okay, but this brings us to the messiest, most debated part of this whole doctrine. Remember that second rule? The one that says the issue has to be likely to repeat for the same complaining party? Well, how courts interpret that one little phrase has sparked a huge legal fight.
So here's the billion-dollar question. Does the rule mean we have to be pretty sure that Jane Doe, the specific candidate who sued, is gonna run for office again under that same restrictive law? Or is it enough just to know that some candidate, any candidate, is definitely gonna run into this same wall in the next election?
And there are two main camps on this. You've got the strict interpretation, which says the rule is the rule. It absolutely must be the same plaintiff.
But then there's a more relaxed view, one you see a lot in election law, that says, hold on, that's way too rigid. They argue that if you're that strict, a state could just keep passing an unconstitutional law over and over, knowing that no single person would ever have time to see a legal challenge all the way through.
And this is not just some academic squabble. The federal courts are literally split down the middle on this. That means, depending on where you live in the U.S., the answer to that question can completely change. The 5th, 6th, and 7th circuits, for example, tend to use that relaxed standard in election cases. But others, like the 2nd and D.C. circuits, stick to that much stricter same plaintiff rule. It creates a ton of legal uncertainty across the country.
So, with all this debate going on, you have to ask, what are the actual limits here? How far can this doctrine be pushed? And where is it all headed? Let's take a look at the boundaries.
Well, the Supreme Court has drawn some pretty hard lines in the sand. For instance, in a 2018 case called United States v. Sanchez-Gomez, some defendants challenged a policy of being fully shackled in court. Their own cases ended, but they tried to argue the exception should apply because, hey, they might get arrested again. The court gave that a hard no. And the reasoning was really clear. They said, look, we're not going to just assume that someone is going to go out and break the law again just to keep their lawsuit alive. The chance of someone committing a future crime is just way too speculative. That's totally different from a case like Roe, where it's a biological possibility, not a voluntary choice to break the law, that makes the repetition likely.
And all of this leads to an even deeper, more fundamental question that legal scholars are still battling over. Is this whole idea of mootness, and the exception to it, a rigid constitutional command that can't be bent? Or is it more of a practical, judge-made rule that allows for some flexibility? The Supreme Court often calls it a constitutional requirement, but many scholars push back and say, wait a minute, if it's an absolute constitutional ban, how can you have any exceptions at all? They argue it's what's called a prudential doctrine, one based on practicality and good judgment.
So that's where we're left. Is this doctrine a vital tool for justice, an escape hatch that makes sure our most time-sensitive rights can actually be defended in court? Or is it a dangerous loophole that lets judges sidestep their constitutional limits and grab power to hear cases they have no business deciding? It's a huge, unresolved tension right at the very heart of judicial power.
This is for entertainment and educational purposes only. This is not legal advice.